So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about an interesting article from Hall Benefits Law about the Americans with Disabilities Act and the attendance policy that they have there. They have a no fault points based policy. And a judge found that it may have violated employees' right to reasonable accommodation. EEOC, of course, filed the lawsuit against AutoZone on behalf of 8 individuals that worked there over 10 years ago. And in it, EEOC said that the employees requested disability-related absences to be excused or covered by a vacation time, and they violated it by not allowing exceptions, which is really interesting and sort of a big problem for many employers with an attendance policy. AutoZone had a 12-point system that went verbal warning, first written warning, second written warning, a serious violation, which I assume is like a final written warning. This is pretty ridiculous. This is a lot of attendance write-ups. But ultimately, if they got 12 points, regardless of fault, they could be terminated. And regardless of fault is a little bit misleading because not completely regardless of fault. They had to consider approved vacation, emergency volunteer responsibilities, of course, FMLA, funeral leave, military leave, jury duty, hospitalization, work-related injuries, or leaves of absence. So really, they had a lot. In addition, they could actually even contest it. And so finally, then the AutoZone regional human resources manager had to review whether or not there was medical issues or something else, which, assuming that 12 points means 12 days, it seems like a lot. I imagine it was over the course of 1 year, and 12 days in 1 year is two and a half weeks or so, not including FMLA and everything else. You could legitimately be off for over 2 months with no problems, really. But EEOC filed a motion for summary judgment, and the court said, well, there are prolonged absences that could justify termination, and the ADA may require an employer to allow an employee ample time off work as a reasonable accommodation for their disability, even though AutoZone's policy already covered that. And that's why it can be very frustrating from an HR perspective when you look at these, because this is a changing of the law. Now, the court hasn't fully confirmed this, and we'll go through probably several court systems before this is ever, a consideration from HR departments. But the ever-changing nature of employment law requires human resources practitioners to be really on the top of their game and to be paying attention at every step, because they may very well be running afoul of the law, even when the law is pretty established and the courts have decided otherwise. What do you think about today's video? Please comment down below, like, share, and subscribe. It really helps out. And I'll see you on the next one. Bye, guys.